Okay, well, welcome to our final panel of the day. We'll have some time after this for stakeholder comments. But this panel is going to explore the connections between the social science research and law and policy. There's been significant developments on the legislative front and policy front in the last 15 years. All 50 states now have anti-bullying legislation. And we can certainly analyze the content of that legislation, and there are frameworks that help us do that. But important questions remain about the impact that the law and policy has had, and implementation questions. And that's one thing that we hope to achieve today is, a review of the law doesn't answer whether the law and policy, how it's being used by attorneys and other advocates, and whether that has been successful in advancing efforts to protect kids from the adverse consequences of bullying and from bullying itself. So we hope to have a dialogue that focuses on two pieces of the puzzle. First, as I just mentioned, how are attorneys and other advocates using law and policy, including in the litigation context? And then second, to what extent is the social science research on bullying informing decisions at the law and policy level as well as at the advocacy level? We have three speakers today, and we've switched the order just slightly, by which I mean entirely. We're going to lead with Craig Goodmark. He's a consultant with the Atlanta Legal Aid Society and an education law attorney, and he'll speak primarily about litigation in the bullying context and related contexts. That will then turn to Sarah Cisse from the Department of Education, who will talk about social science research and law and policy development. And then finally, we'll hear from Sally Burns, professor of clinical law at NYU, about some of her research on and legal work on sexual assault, violence, and other forms of victimization. So with that, I'll turn it over to Craig. Each speaker is aware they have 15 minutes. If you're in the room, it would feel like the Supreme Court, where you get a red light when your time's running out or has run out. I will be the virtual red light for those of you who are dialing in. Craig, whenever you're ready.
Great, and thank you so much for having me. My name is Craig Goodmark. I am an attorney at Atlanta Legal Aid Society. I'm actually now a consultant with Legal Aid, and I have an education civil rights practice here in Atlanta, Georgia.
Hey, Craig, we are unable to see your slides.
Excuse me?
Craig, we cannot see your slides.
Let me, I haven't gone to any yet, but let's see, how are we doing now? Better?
Yes.
And let's move these and make them bigger. How about that?
That's perfect. Thank you.
Great. Thank you. We've been handling bullying cases down here in Atlanta for some time. The law, such as it is, has really trickled into play over the last 10 years, but that's the state law. And what I wanted to talk about today is kind of just to give a brief landscape. I'm sure everybody in the room is aware of the impact, or the interplay between the federal government and the state governments with respect to these kinds of issues, to talk a little bit about some of the litigation techniques that have been tried and to maybe project into the future some of the litigation techniques that may be used in the future. So because bullying reaches into and this is constitutional or statutory language from Georgia, which I think may be stronger than some other states around the country, but here it is absolutely gospel with school districts that when you deal with the control, operation, and management of schools, you're dealing with some sacred ground, county by county, district by district, and for sure the U.S. government, it would be limited here in Georgia in what they could do to address this issue. There are some federal funding programs that incentivize anti-bullying, but there is no anti-bullying law per se, and I'm sure we're all clear on that. States have passed education-specific laws that address bullying, as opposed to, and now I'm speaking as opposed to discrimination laws or anti-discrimination laws. Anti-discrimination statutes like Title IX, Title VI, Section 504 of the ADA, and to some extent the Individuals with Disabilities Education Act, they prohibit discrimination. Our education laws don't necessarily go that far. They are what I term administrative statutes. They deal with the regulatory framework in schools, what policies need to be in place, what are the frameworks or the definitions that we'll use for these policies, and to ensure compliance from the district as opposed to ensuring compliance from the district employees individually. And so you have this dichotomy where the state is handing down to the local districts the responsibility to pass policies and to make sure that these anti-bullying policies are enacted and then implemented, but the state itself, at least in their opinion, fulfills their responsibilities simply by passing the statute, giving them the broad strokes of what the definitions would be and what each policy should have in it. In Georgia, the anti-bullying law, such as it is, would be really sifted down into the local codes of conduct. And these are behavior codes of conduct that each school district will promulgate. They're specific to each district. There's only a few basic requirements look in our state regulatory scheme. But the local school districts have the control to create the bullying language, to create the spectrum of disciplinary actions that would be used if there is bullying, and then to ensure the implementation of those policies in each school. My experience has been that the statute and these policies have some limitations and inherent challenges. I've listed three here that you can see: cyberbullying, bullying outside of school grounds or outside of school jurisdiction, and one that I've recently come in contact with, which is group bullying. And I was having a conversation with Sarah, and she was mentioning that group bullying and the stigmatization of the victim and the victim's group. And I was thinking back and reflecting and realized I had actually had that phenomena happen in cases that we've handled, mostly for kids with disabilities. And we'll talk a little bit about how we address that as we go forward. One of our main statute has a three-strike rule. And the three-strike rule says on your third act of bullying as a perpetrator, you'll be removed from the school and sent to the alternative school. Here's an inherent limitation. You got a group of 4 bullies, and they theoretically could complete 8 coordinated acts of bullying in the same school year without ever triggering that sanction. Now, that's unbelievable, and it's very hard to control, much less to pursue as an attorney trying to defend somebody, or simply to try to make a case that these policies aren't working. For bullying outside of school, in Atlanta, for instance, the only responsibility that a school has, if they hear about it, is just to report to the parents that this may have occurred. They will not investigate. They will not take any disciplinary action. And so a victim who is bullied 5 feet from the bus stop may not have any recourse. It may not trigger our bullying statute or the local policy, and the bullier may continue to harm the victim throughout the school year. So these are natural limitations that we have in our policies. As in most circuits and most jurisdictions, bullying has been addressed as peer-to-peer harassment. The claims will arise under Title IX, which is a gender discrimination statute, but the analysis has been applied to peer-to-peer harassment. Claims have been raised under Title VI, and claims in our office most effectively have been raised under 504 in the ADA with respect to disability, as well as the Individuals with Disabilities Education Act. In these types of claims which are brought into federal court with no exhaustion requirement in an administrative context, the essence of the claim will lie in, 1, the severity of the harassment, and 2, the effectiveness of or the ineffectiveness of the school response. And so a victim who is going to bring a lawsuit to try to control bullying or try to raise claims against the school district for failing to control bullying is going to have to show, one, that it's a very severe case, especially down here in the 11th Circuit, where it's not a plaintiff-friendly place, and we do have to make some, very, very strong showings. And we can talk a little bit about some of the facts that have not been upheld as bullying or have not resulted in liability. Excuse me. And then the second prong is the effectiveness of the school response. There will be two hurdles that would need to be cleared in a federal lawsuit under Title IX, Title VI, or the ADA. The first is the victim would have to show the elements of the peer-to-peer harassment are established. One, that the victim was actually harassed. Two, that the school district had knowledge of it. And three, and this is the key, that there was no effective remedial action taken by the district. And that would establish liability. But if you were going to move forward with that case, and really lawyers that are taking these cases are taking them to pursue a damage claim on behalf of the victim against the district and individuals, you're going to have to clear the immunities that attach not only to the public agency, but to those officials that are working in their official capacity. And so you have a long road under these federal claims. And in fact, here in Georgia, we had, let me go back. Here in Georgia, we've had some truly egregious sets of facts come before federal judges, and the judges applying the law as it exists in the 11th Circuit just simply have not found that there was ineffective remedial action, that there was what's termed deliberate indifference to the harassment. Judge Murphy up in Rome, Georgia, which is the northern part of our northern district, wrote an 186-page opinion, of which 2/3 were the facts of the harassment or of the bullying. That was a severe case of bullying over multiple years, and even with that, with the 100 pages, 120 pages of facts about how bad the bullying was, at the end of the day, he had to say, because of this standard of reckless indifference, and that the school did take did take some action, that there was no liability on behalf of the district or the individual, and so the plaintiff in that case wasn't able to prevail. Now, there is a new theory being pursued in the courts, and it involves using the Individuals with Disabilities Education Act, IDEA. It's 20 U.S.C. 1400. IDEA is a prospective statute as opposed to a prohibitive statute. Prohibitive statutes prohibit discrimination. Prospective statutes tell the court and tell the school district what they would need to do in order to ensure that a child is accommodated and receives a free, appropriate public education. Recently, over the last 5 years, the federal government has said that bullying of a student receiving special education services can be a denial of their right to a free, appropriate public education. Denying FAPE, as it's known in special education worlds, establishes liability on behalf of the district or for the district to that student, and that student could pursue a claim. It would not be a claim for damages right off the bat. The claim would be for compensatory education services, which in some of these cases usually looks like a private school placement with the school district reimbursing tuition and all the other educational services that would be necessary in order for the student to have an appropriate education elsewhere. Unlike claims under Title IX and Title VI, you don't have to make this reckless indifference showing. And so I wanted to just use two cases as a comparison. In Long versus Murray County, which is the case I was just telling you about, and I've posted the judge's decision, or I've given it to the organization so they can post on the webpage as materials in support of our talk today. The district court held that the defendants were neither deliberately different or clearly unreasonable when they did the following. They never had a speaker come in to talk about bullying. They had no policy for anonymously reporting bullying. They never provided teachers with any training. They ignored multiple complaints and failed to take effective remedial measure. Those were the facts the plaintiffs put forth, and because of the procedural way the case was taken, had to be accepted as true. And even with those facts, the judge did not make a finding of liability against the district. The bar is just so very high in these cases. If you compare that to a case that was recently litigated up in New York in the Second Circuit, but this is a district court opinion, it was a bullying case that was litigated through the special education lens. The parents, instead of filing a lawsuit, filed an administrative action through the state administrative procedures, which is deemed a request for administrative due process. In that action, their theory was that the bullying denied the child a right to a free, appropriate public education. The parent argued that the child was not offered a FAPE because the IEP team, and these is going to get into some special ed law that I don't want to dive too deep into, but the educational planning team refused to take the parents' concerns about bullying into account when they drafted the educational plan, that the educational plan was not designed to ensure that bullying did not substantially restrict the opportunities of that year. And in this particular case, the child was absent from school because of the bullying. The child was suffering from anxiety because of the bullying, obviously. And there were opportunities missed, things that the child would not go to because of this bullying situation. And what I thought was particularly an interesting piece of this case, the parents alleged that the IEP goals themselves, so the educational planning goals for this child, were not written so that a parent would understand that they were to address the bullying. And if you look at the case, and I've provided the opinion as well, you'll see these documents are so heavy, they're so intense with educational speak that a parent trying to just meaningfully participate would have had to have been a master's level in education or behavior management to know that this is what we're talking about. We're talking about bullying here. And because the court said this is undecipherable, to a parent, you've denied the parent the right to participate, and that in turn is a denial of faith. Here in Georgia, we have started using the same theories. We did not use the arguments used in New York, but we did raise the issue of being denied your access to the educational program, just simply not being able to come in the building. Our client was absent from school for weeks at a time because of the anxiety that he suffered from being bullied. A child with Asperger's syndrome who has social delays, already. Managing that type of environment is very difficult, and those are the types of claims that we raised in that case. We were able to settle the case and have the child removed to a private school, but I thought that we were particularly effective raising this issue, the harassment on student issue, through the lens of special education, and I think that's an interesting development. I think I'm coming up on what I believe is, that's the end of my slides, and I'm happy to discuss with you today. The use, and I'll just try to segue into the next speaker, we were not, because of course we work at Legal Aid and we work on a shoestring, we did not have experts in our case. I am aware that there are experts out there talking about this issue, opining on this issue. In the Long case, there were multiple experts there to testify that the child had been harassed, had been bullied, and that had caused the causation piece, which is always so difficult in this case, the effect. In that particular case, Long versus Murray County, the child committed suicide. So we had multiple experts there. We have not been able to use those experts, and I hope that through these discussions we continue to develop some of this resource so that people in the trenches like we are down here at Legal Aid will know that this science exists and that it can be used to support some of the work that we're doing.
That's great. Thank you, Craig. We're going to move directly to Sarah now.